Disclaimer: the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Hello, welcome to the closing arguments section of the University of La Verne Justice Center website. Glad to have you. First, we're going to start with where you are in the trial process. You have reached the end of your trial. All evidence has been presented, and all witnesses have been examined. It is now time for the closing arguments phase of your trial. The closing arguments phase takes place at the end of a trial and is the concluding statement addressed to the jury by the lawyer for each side of the case. The lawyers summarize the evidence that was presented during the trial, his or her client's position, and why the verdict or decision should be granted in favor of their client. An effective closing argument ties together all the pieces of a trial and tells a compelling story. After this phase is the verdict or decision. The verdict or decision is made by the jury. The closing argument phase is very important because this is your lawyer's last chance to convince the jury to decide in your favor. The purpose of this phase of the trial is to give both parties a chance to convince the jury to decide in favor of your defense or claim. This is accomplished by framing the issues and telling the jury how each element is the law or is not met by the facts. What do you need to accomplish during this step? During this step, attorneys should outline the facts of the case by summarizing the evidence and the witnesses presenting the evidence and showing how that evidence proves their side of the case based on the law. This is done by going through the evidence, witnesses, and law in an organized fashion that spells out to the jury exactly why they should decide for you in your case. Next is some general information about closing arguments. First are the parties who are involved in the trial. The parties involved in a trial consist of the prosecution, the defense, the jury, and the judge. Next is the process of closing arguments. Closing arguments take place at the end of the trial. The plaintiff first presents their closing argument to the jury. The attorney sums up and comments on the evidence that was presented during the trial in favor of the plaintiff, explaining how the evidence proved the plaintiff's claims. The defense then presents its closing arguments. The defense then responds by answering statements made in the plaintiff's argument, pointing out weaknesses in their case, and summing up the facts that are in favor of his or her client. Since the plaintiff has the burden of proof, the plaintiff is therefore allowed a response. There is a chance for the plaintiff to respond to the defendant's points and make a final appeal to the jury. The defense could choose whether or not to respond with another closing statement. If so, the plaintiff loses the right to make a second argument. There are different parts that make up a closing argument. Closing arguments should include a hook, a theory or theme, a summary of facts, a summary of evidence, a summary of witness testimony, an explanation of law, an argument and rebuttal, a request, and a conclusion. This has been an overview of the closing arguments section on behalf of the University of La Verne Justice Center. We thank you for your time. I hope this information is helpful in your legal matter.